Good morning, this is your Kelso Report for Monday, August 15th, and I'm your host, Clark Kelso. We are an aging population, and at the same time, the resources available to care for the aging would appear to be shrinking over the next 30 years. This will inevitably create tension that will play out in an increasing number of cases alleging elder abuse. Abuse that may encompass medical abuse, mental health abuse, economic abuse, and so on. Well, in today's featured case, Carter v. Prime Healthcare Paradise Valley, the 4th District reviewed a complaint alleging elder abuse, willful misconduct, and wrongful death, which had been dismissed by the Superior Court on a demurrer. The elder abuse claim was dismissed because the plaintiffs had not alleged conduct that qualified as elder abuse under the statute, as distinguished from mere negligence. The willful misconduct and wrongful death claims were untimely. The 4th District affirmed the dismissal. The facts were, unfortunately, not particularly out of the ordinary, albeit the result was, of course, bad. The decedent was 87 years old. About 2 months after undergoing hip surgery, he was admitted to the defendant hospital for chest pain. 2 days later, he was transferred to a skilled nursing facility also owned by the defendant. According to the plaintiff, he was not treated well at the nursing facility. For example, when bathed in bed, he was routinely not dried fully and instead was placed in front of an open window with a fan blowing on him to air dry even on cold days. At least that's the complaint. He was also allegedly not provided sufficient nutrition or hydration. Within 3 weeks, he weakened and developed pneumonia, pressure ulcers on his lower back and buttocks, and sepsis. The decedent was transferred back to the hospital for 8 days for treatment of pneumonia, sepsis, and pressure ulcers. He was then transferred back to the nursing facility for about 3 months. Allegedly, he continued to be mistreated at that facility. They left him isolated, not repositioned, and improperly bathed. He was returned to the hospital a 3rd time, and when he suffered a sudden cardiac arrest because of a crash cart that had not been properly stocked, he allegedly died when those treating him could not locate a common-size endotracheal tube to intubate him in time to save his life. Now, according to the statute, the Elder Abuse Act, a plaintiff who proves by clear and convincing evidence both that a defendant is liable for physical abuse, neglect, or financial abuse, and that the defendant is guilty of recklessness, oppression, fraud, or malice in the commission of such abuse, may recover attorney's fees and costs, and if the elder died as a result, his personal representative or successor in interest is partially relieved of the limitation on non-economic damages otherwise imposed by Section 377.34 of the Code of Civil Procedure. And he may recover damages then for the decedent's pre-death pain and suffering. Neglect is broadly defined under the Act and refers basically to the failure of those responsible for attending to the basic needs and comforts of elderly or dependent adults to carry out their obligations. It is clear that to recover under the enhanced remedies provided by the Act, a plaintiff must prove more than simple or even gross negligence in the provider's care or custody of the elder. Instead, the plaintiff must prove by clear and convincing evidence that the defendant had been guilty of recklessness, oppression, fraud, or malice. In essence, the same standard used for the award of punitive damages in an ordinary negligence case. Well, in reviewing the complaint, the 4th District came to the same conclusion as the Superior Court. Namely, the complaint failed to allege that the hospital did anything sufficiently egregious to constitute neglect or abuse within the meaning of the Elder Abuse Act. It is worth noting that the nursing home's conduct was not at issue on this appeal. The demurrer had been granted with respect to the hospital, and it was only the hospital's conduct that was at issue. The defendant's first 2 hospitalizations appeared to have passed without significant incident. There was no allegation that the hospital denied or withheld any care or treatment from the decedent. As for the 3rd hospitalization, although the crash cart was not properly stocked, plaintiffs admit the hospital personnel immediately searched throughout the hospital to locate the proper-sized endotracheal tube. So at best, the complaint alleged professional negligence. But absent more particular allegations to show a conscious or deliberate disregard of a high probability of injury to the decedent, the complaint simply did not rise to the level of abuse or neglect within the meaning of the Elder Abuse Act. As for the willful misconduct and survivor claims, the court held they were essentially claims grounded in professional negligence, and the 3-year statute of limitations therefore applied. The plaintiff suspected the day her father died that the death was caused by wrongdoing, and given that allegation, plaintiffs had until August 18, 2009 to sue the hospital. Unfortunately, they did not initiate their action until a little over 2 months later, on October 27, 2009. And I suspect there's a lawyer out there who owes them an explanation about that delay. Well, now our one-liners. First, in the area of civil procedure and standing. In Baldwin v. Sebelius, the Ninth Circuit affirmed the district court's dismissal of a suit challenging the Patient Protection and Affordable Care Act, Obamacare, on standing grounds. The individual plaintiff in the case did not allege that he does not have qualifying health insurance or that he would not have it in 2014. And the organizational plaintiff, the Pacific Justice Institute, failed to allege that the individual mandate applies to it, or that it has enough employees to be subject to the Act's shared employer responsibility provision. Absent those allegations, there was no injury in fact sufficient to confer standing. These are obviously problems that can be fixed by amending the allegations or finding plaintiffs, but it looks like this case is going to miss the parade to the Supreme Court. Next, in the area of child support. In In Re Marriage of Boto, the 6th District held that for purposes of determining whether to modify a child support order, the interchangeable legal standards include a change of circumstances, material change in circumstances, substantial change in circumstances, and change of condition. All of these standards apparently ask basically the same question. Was there such a change in income as to merit a reduction of a child support obligation? On the particular facts presented, the 6th District affirmed the lower court's conclusion that there had been no change in circumstances. The father's income had not significantly changed over a 4-year period. Next, in the area of immigration. In Pinto v. Holder, the Ninth Circuit reconfirmed its earlier holdings that a decision by the BIA to deny asylum, withholding of removal, and protection under the Convention Against Torture, but to remand to the immigration judge for voluntary departure proceedings, is in fact a final order subject to judicial review. The reason this is a final order, notwithstanding the remand, is that the only issue on the remand is how the alien will be deported, not whether the alien will be deported. So when the Bureau of Immigration Affairs, Board of Immigration Affairs, decision to deport is a final order and is therefore appealable. The court held that neither the Supreme Court's decision in Dada v. McCasey nor some recent amendments to the regulations regarding voluntary departure undermined the Ninth Circuit's earlier holdings on this appellate jurisdiction issue. Now we turn to public employment, where in Alabs v. County of Los Angeles, the Ninth Circuit held that a county policy of denying relief at a post-suspension hearing to a police officer who has been charged with a felony may violate due process, since the denial of relief is essentially predetermined and occurs irrespective of the actual validity of the criminal allegations stated in the charge. Prior Ninth Circuit cases had established that a police officer charged with a felony is not entitled to a pre-suspension hearing, but the county is still required to provide some type of meaningful post-suspension process. However, the court also held that all of the individual defendants, the members of the Civil Service Commission, the county board, and the sheriff, were protected from damages by qualified immunity, since a reasonable official would not necessarily infer from existing case law that a post-suspension hearing that's limited to the question of whether a felony charge has been filed was unconstitutional. Next, under the False Claims Act, in Lee v. Corinthian Colleges, the Ninth Circuit reversed a dismissal of a complaint in a case arising under the Federal False Claims Act. According to the complaint, Corinthian had falsely certified to the Department of Education its compliance with the federal ban on recruiter incentive compensation in order to receive substantial federal education funds. Corinthian claimed it fell within a safe harbor provision for fixed compensation for recruiters, but the allegations in the complaint indicated that pursuant to the defendant's compensation program, recruiters received a 2.5 to 10% annual salary increase, were exceeding certain enrollment quotas, and recruiters that did not hit minimum targets were terminated. The Ninth Circuit held that the complaint did not allege with sufficient particularity facts to establish that the compensation program and its employee performance rating system was merely a proxy for employee recruitment numbers, which would take the program out of the safe harbor. But the court reversed the dismissal to give the plaintiffs an opportunity to amend the complaint, if possible, to cure this defect. Finally, an immigration case in a criminal context. In United States versus Margaret, Pilato, the Ninth Circuit held, over a dissent, that the defendant, who was charged and convicted of being a previously removed alien found in the United States, was entitled to have the jury instructed on the definition of derivative citizenship. The government argued that in a prior appeal from a bench trial in the case, the Ninth Circuit had already determined the defendant was not a derivative citizen as a matter of law, so the jury should not have been instructed on the doctrine. Well, the panel in Friday's decision rejected this application of the law of the case doctrine, holding that the law of the case doctrine cannot constitutionally be applied to bar the use of a defendant's proposed jury instruction where that instruction is legally correct and supported by a foundation in the evidence. The court also noted that the evidence in the second trial was different than the evidence in the first trial, which made the law of the case doctrine inapplicable in any event. So, back they go for a third trial. And that's your Kelso Report. I'm your host, Clark Kelso. Have a great day in the law.